Yeah, the entire event is now being recorded. I once again welcome you all for this event. So I'd like to make a few things clear to all the participants. Kindly enable mute from your end and do not disturb or unmute in between the session. Opportunity will be given to all the interested participants to ask questions after the special speaker's presentation. Kindly do not disturb the speaker or the fellow participants in between. If there is any trouble in viewing this webinar, disconnect and try connecting again. Before I start introducing our special speaker, I take immense pleasure in welcoming our special speaker, Advocate Sai Deepak ji, to this program. The moment we planned to conduct a webinar series, all of us in our team wanted Sai ji to inaugurate and start the first webinar. When I approached Mr. Sai with this idea, he immediately accepted our invitation without any ostentation and gave us his valuable inputs also. Our speaker for today requires no introduction as he is known from Kashmir to Kerala. Yes, I mean it. Mr. Sai's speech on abrogation of Article 370 and his views and arguments on Sabrimala temple case are gems to all the law students and also to legal experts. And in case if any one of you have missed those speeches, they are available on YouTube and I recommend you all to go and watch it once, to know about the gravity of the issue and also to see the knowledge and eloquence of Mr. Sai. I consider this as my privilege to introduce Sai Deepak ji. He is an engineer turned law firm partner turned arguing counsel. He has a bachelor's degree in mechanical engineering from Anna University and a bachelor's degree in law from IIT Kharagpur. Mr. Sai has been a litigator since July 2009 and was an associate partner at a leading NCR-based litigation firm, Sai Krishna and Associates, until he went independent in June 2016. Mr. Sai founded law chambers of J Sai Deepak in June 2016 and set up practice as an arguing counsel. Apart from his clients who have retained Mr. Sai, he is engaged by soliciting law firms and individual solicitors to appear before Supreme Court of India, the Delhi High Court, the Bombay High Court, the Madras High Court, the Competition Commission of India, the Competition Appellate Tribunal, the Intellectual Property Appellate Board, and tax tribunals. In a decade's practice, Advocate Sai has carved a place for himself in civil commercial litigation, IP litigation, information technology law, competition law, constitutional law, and indirect taxation. Mr. Sai has advised, represented, and argued for clients in diverse domains such as the pharmaceutical industries, e-commerce, and the telecom sector. Over the years, he has been a part of several landmark cases like he was a part of the team which represented Greenpeace in Tata Sons versus Greenpeace 2011 and played a vital role in the outcome where the Delhi High Court laid down the laws and the interplay between constitutional freedom and IP rights. Since March 2013, Advocate Sai has been representing prominent Indian and Chinese mobile brands such as Intex and Xiaomi against Ericsson in the ongoing standard essential patents litigation before the Delhi High Court, the Intellectual Property Appellate Board, and the Competition Commission of India, wherein issues relating to interplay between IP rights and competition law arises for consideration. As a part of these litigations, in March 2016, the Delhi High Court pronounced a landmark verdict where the jurisdiction of the CCI over the conduct of the IP owners were established. Since 2011, Advocate Sai has represented Basmati rice farmers from the state of Madhya Pradesh in the ongoing Basmati geographical indication litigation before the Madras High Court, the Delhi High Court, the IPAB, and the Geographical Indication Registry. As a consequence of Mr. Sai's successful representation of Basmati farmers before the GI Registry, in 2013 December, he was appointed as the counsel for the state government of Madhya Pradesh, and in 2016 to represent it in the ongoing second round of the proceedings in the case before the Madras High Court, the Delhi High Court, and the GI Registry. In March 2015, Mr. Sai successfully led the team which represented the Internet and Mobile Association of India before the Honorable Supreme Court in the constitutional challenge to the intermediary liability regime under the IT Act 2000 in Shreya Singhal versus Union of India. In the said decision, the Honorable Supreme Court held that in the absence of a court order directing down of content, an intermediary had no obligation to remove content upon mere receipt of a notice. He continues to advise and represent e-commerce entities such as ShopClus on issues relating to and intermediary liability. In March 2017, he was a part of landmark decision of the Delhi High Court in Sanjeev Kaila versus Union of India and another, which recognized the right of members of Indian armed forces to supply of safe equipment as a part of their right to life under the Constitution. In October 2017, Advocate Sai successfully argued before a bench of Madras High Court in Lifestyle Equity CV versus OD Seatman Designs Private Limited and others on arbitrary of IP disputes. In January 2018, Mr. Sai successfully argued on the interpretation of Section 124 of Trademarks Act 1999 before the Honorable Supreme Court. Patel Field Marshal Agencies versus PM Diesels Private Limited. In July 2018, Mr. Sai argued on behalf of the ready-to-wait women campaigners in the Sabarimala Ayyappa temple petition before a constitution bench of the Supreme Court, which were widely reported by the national media. Since November 2016, Mr. Sai has been engaged by the Department of Industrial Policy and Promotion, Ministry of Commerce, Government of India as an honorary advisor on the implementation of national IPR policy. Since June 2017, Mr. Sai has been the mentor to the legal team of the Indic Collective Trust, which is at the forefront of advocating Indic civil liberties through democratic and constitutional means. Mr. Sai is also an avid legal commentator and has articles to his credit in reputed international journals such as Mark Planck Institute's International Review of Intellectual Property Law and Competition Law, and national journals such as Indian Journal of Intellectual Property Law and Journal of Intellectual Property Rights. He has won international and national legal writing competitions. As on 2018, the legal writing competitions of International Association for the Advancement of Teaching and Research in Intellectual Property. He has been invited in the past to present his views on important legal developments by platforms in India and abroad. He also blogs on legal issues. As a law student, his blogspot on the Bajaj TVS patent dispute was cited extensively and relied upon by a division bench of the Madras High Court to vacate an injunction granted by a single judge of the court, making it one of the rare instances in Indian judicial history where a law student's work was cited and relied upon by the court. His blog, The Demanding Mistress, is widely read by legal practitioners, lawmakers, academic and policy analysts in India and abroad. I have presented to you just a small fraction of his achievements, and even the entire webinar's duration of 1.5 hours is not sufficient to introduce our special speaker. On behalf of the organizers, AP Legal Chambers, the participants, and on my personal behalf, I welcome Advocate Sai Deepak ji to this webinar. This session shall be an interactive one. You can ask questions to this and to the speaker, and the same will be answered by our special speaker. Now, I hand over the session to Advocate Sai ji. Over to you, Mr. Sai.
Thank you, Anand. Thanks a lot for the kind introduction and your warm words. There's a decent chance that the profile may have exaggerated some of my achievements, but be that as it may, I'm very, very grateful to you for the warmth and the cordiality with which you've invited me to this particular platform, giving me an opportunity to interact with members of my fraternity, or a fraternity of which I'm a member. For the last few months, I've been trying out a slightly different style of interaction with members of the audience. For the longest of times, I think I was relying on a monologue or a lecture style session, which I think is slightly outmoded and is not particularly consistent with the conversational style that the Indian thinking effectively encourages. So, which is why I suggested to Anand, that he was kind enough to agree to this, that I am going to spend about 15 to 20 minutes at the best, trying to give you a short and a brief background to the topic, place before you the broad contours of the issues involved. And then I'd like to understand from members of the audience what is it that they specifically wish to understand as part of this topic. And I'm going to keep it as interactive as possible. And questions which are relevant to the topic are welcome. And please feel free to ask any question without holding them back, because this area, especially the intersection between intellectual property and competition law, is still relatively nascent, and there is a lot of room for ideation, and there's a lot of room for contribution from various people. So I don't think, at least I qualify as an expert. I don't think I qualify as an expert on this particular subject because I'm still learning. So let me just try and share with you my experience of dealing with this particular subject so that you understand where I'm coming from. And as part of that, I'll address some of these issues. So as Anand was kind enough to point,
yes. Sorry to interrupt. There are so many law students who have joined for this webinar, right, especially after they came to know that this topic is being presented on IP and competition law. Right. So I think there will be a lot of questions from the student, and I request you to just address them in such a way that they also find it easy. It is easy for them to understand.
Fair enough. In fact, I'm happy that a lot of law students have actually joined. I'm more than happy to answer questions from law students. And I'll try and keep this as lucid and as simple as possible so that even a first-year student of law or even a non-practitioner, non-law student can understand the subject. I'll try to keep it that simple. Now, coming to the subject. So since 2009, one of my areas of core competence, or at least my primary area of core competence as far as practice goes, has been intellectual property law. And even my approach to competition law, or for that matter, even constitutional law, has been largely influenced by my interplay with these areas as primarily an intellectual property rights practitioner. Therefore, some of the points, or at least my views, are going to suffer from the bias of someone who is primarily an intellectual property rights practitioner or a civil litigation practitioner, as opposed to being an expert of competition law exclusively. That is something that I would like to underscore here as a caveat and as a disclaimer, so that I don't end up projecting myself as someone who's an expert on a certain subject which he is not. So I'm not going to call myself an expert of competition law, but I certainly understand the interplay between intellectual property rights and competition law based on the limited experience that I've had before the Delhi High Court, as well as the Competition Commission, and previously the Compat, and now I think it's part of the NCLAT. So one of the first questions that you end up asking as a student of intellectual property is if intellectual property rights fundamentally represent certain forms of limited monopolies, and I'm capturing this in as crude and as broad a fashion as possible, and there's a lot of nuance there. I'm not unpacking all the nuance here. I'm just trying to give you the flavor of the subject from perhaps 60,000 feet. So if intellectual property rights is largely seen as a form of monopoly or different forms of monopoly, limited monopolies that are given to owners of intellectual property, of different forms of intellectual property, be it copyrights, inventions, trademarks, geographical indications, semiconductor registration rights, or semiconductor layouts, or industrial designs, or plant varieties. The concept of a limited monopoly at the outset and on the face of it comes across as anti-competitive. Because if the idea of competition is meant to give the impression of a level playing field, to the extent that a level playing field is possible in a free market, or at the very least, it gives the impression that there is no person who can actually claim monopoly over something that is mental, or something that is intangible, or something that is in the mind, or that is the product of the mind, then how does one not treat intellectual property rights itself as a form of an anti-competitive form of right? Is intellectual property at loggerheads with the concept of free competition is the fundamental question that we are trying to address. Because you see, when it comes to patents, there is a strong and a limited period of right of 20 years from the date of filing of the patent application that is available to the patentee as and when the patent is granted to the person. Then when it comes to copyrights, you have a 60 or a 70-year period plus the life of the author's life plus 60 to 70-year period. So these are the different life, let's say the tenures that are available, or the terms that are available to different forms of intellectual property rights. In such a situation, as long as those forms of monopolies exist, or as long as those forms of rights exist on a certain subject matter, that subject matter is not available for use and for exploitation in any manner by third parties, especially competitors in a market, subject to certain limitations or certain exclusions. So, for instance, research-based exclusions, public interest exclusions, compulsory licensing-based exclusions. Other than these forms of exclusions, intellectual property rights, for all practical purposes, represent a very strong form of monopoly, which skew the competition or which skew the market in favor of the person who owns those rights. Let me try and simplify this as much as possible, which is to say, if you own a form of intellectual property with respect to a certain subject matter in a given industry, the assumption that flows with that particular form of ownership is that it gives you a certain advantage over and above the advantage that your competitors have in that particular field or in that particular fraternity. May I request the rest of the participants to mute their microphones, please, because it's disturbing my flow and concentration. Thank you. Very grateful. So, therefore, as a practitioner of intellectual property rights, while you may have justifications to support this form of property right, the question that one must ask on a larger canvas is whether intellectual property rights is fundamentally incompatible with the concept of a free market and with the concept of fair competition. Because you see, ultimately, what the law is expected to frown upon is unfair competition, is monopolistic practices or restrictive practices which prevent other members from entering a certain business sector of business, or which prevent existing members from doing what they're otherwise allowed to do, or from being able to pursue their legitimate interests. This perceived tension between intellectual property rights and competition law is what I'm trying to, I'm going to try and shed some light on, and then leave it for you to ask me certain questions. Now, what is the fundamental premise behind intellectual property, whether it is a stumbling block or whether it is an impediment to competition or whether it facilitates competition, is the primary question that we must try and address. Now, the primary assumption which underlies the jurisprudence of intellectual property rights, regardless of the specific forms of intellectual property, I'm talking of intellectual property as a species in itself or as a genus in itself, is that when you own a certain form of intellectual property right and you have a certain form of monopoly, what you're forcing your competitors in that particular business to do is to effectively adopt the following courses of action. Either they stay away from what belongs to you, or they try to work around what belongs to you, or they take a license from you for what belongs to you. These are the three options available to them. Or the fourth option could be that they try and invalidate and challenge your ownership over this particular form of intellectual property or the subject of that particular form of intellectual property. Okay, so these are the four courses of action. So let me summarize it once again. Either they can adopt a hands-off approach, which is they stay completely away from your form of intellectual property right. Second, they try and challenge your ownership and say that what you have rights over does not belong to you, or that you have been granted rights over something which fundamentally belongs in the realm of commons. That is something that should have been in public domain has been appropriated by you in the form of intellectual property right to the detriment of the rest of the market. The third option is for them to try and take a license from you so that they can legitimately practice or exploit that form or the subject of that intellectual property right. And the fourth option, which is available to them, is that they try and overcome your right in a slightly different fashion. So let me make it concrete with an example. Assume for a moment that you have a patent over, let's say, a certain pharmaceutical drug with respect to a life-saving, or let's say a life-threatening disease or a life-threatening disorder. Then if you happen to be a competitor to the person who owns that patent, you can either file a revocation petition seeking the invalidation of that particular patent so that there is no patent over that subject matter at all and it is free for everyone to use. Okay, or you can choose to stay away from that particular subject matter which is covered by the patent altogether, and you maintain a completely hands-off approach to the patentee or from the patentee. 3 is that you ask the patentee to grant you a license so that you're in a position to practice or manufacture that particular invention or the subject of the particular patent. 4 is that you try and create a non-infringing alternative, which is to say that you try and achieve the same goal without infringing the patent and finding a work around, so to speak, so that you're in a position to create a different path to the same destination. These are the 4 different options, assuming that you happen to be in the realm of patents. Now, therefore, what intellectual property rights forces the competitors to do is to try and improve on the product as much as possible so that they're in a position to offer a better product or a cheaper product to the consumer, so to speak. Now, in theory, what this is expected to do is that when 2 people constantly fight with each other by way of trying to improve upon the product that they're putting out in public domain for the public consumption or for the consumption by the purchasing members of the society, then they are trying to increase the basket of options which is available to a certain consumer. Now, when 2 people fight on this kind of an issue, where they're trying to create more options for the consumer, this effectively becomes what is known as dynamic competition, and it increases dynamic efficiency, which is to say that the market is constantly moving and inching towards an ever better set of options for the consumer. Now, if let's say if dynamic competition is one form of competition, then the question that must arise in the mind is, then what is non-dynamic competition and what is static competition? Static competition is typically a situation where 2 competitors in the market are not fighting on improving the quality of the product or are not trying to present a better version of the product, but they're primarily fighting on price margins, on profit margins, which is to say that they're trying to cut down on the cost of production so that it is easier for them, or it is possible for them to sell the product at a cheaper price. If somebody sells it at $30, his competitor would try and sell it at $25. Therefore, the entire fight revolves around certain parameters which don't increase the basket of options for the consumer in terms of better products, but which only tries to improve the circumstances in which the access to the product becomes better. That means you can buy the product at a cheaper price. So intellectual property, what it does to the concept of competition in the market is that it tries to introduce something called as dynamic competition, wherein every competitor or every market player is expected to come out with a better set of options in order for him to be able to survive in the market. And therefore, if you're not in a position to keep pace with the particular market, then you're bound to be reduced as an obsolete player in the market and you'll be rejected by the market altogether. So that is the pressure, that is the incentive, and that is the driver that intellectual property rights performs as a role. Therefore, it constantly pushes participants in a market in a certain direction where it increases the basket of options. That is the theoretical framework, of course. But the flip side to the ownership of intellectual property rights, which effectively upsets this assumption, is that when a right owner of a certain form of intellectual property effectively exercises that form of intellectual property in a manner that it poses an entry barrier to anyone who wants to enter that market, or which takes away the legitimate exceptions and the legitimate defenses and the legitimate exclusions which are available within the statutory frameworks of intellectual property rights, then the exercise or exploitation of intellectual property goes beyond acceptable limits and effectively becomes anti-competitive in nature. Simply stated, intellectual property which is meant to facilitate a certain form of competition could be exercised in such a way that it becomes anti-competitive in the manner in which it is flexed, anti-competitive in the manner in which it is asserted, and anti-competitive in the manner it is enforced against a third party. So sometimes what could happen is that just because you have a patent in your hand with respect to a certain drug, and there is nobody else in the market who has actually come out with a better alternative to challenge the monopoly of your product, and who is not in a position to offer a cheaper version of the same product or an affordable version of a different variant of the particular product, then that hands you so much of market power that you may end up becoming greedy to the extent of charging exorbitant prices for access to that particular product. And thereby you could trigger certain mechanisms within the Patents Act and certain mechanisms outside of the Patents Act. So for instance, if you look at any form of intellectual property, whether it's copyrights or if you're talking of patents, there are certain mechanisms within the Patents Act and there are certain mechanisms within the Copyright Act which are meant to prevent the right owner from exploiting or enforcing the right beyond acceptable and reasonable limits. So some of those forms or some of those mechanisms I'm sure you're aware of in the form of compulsory licensing mechanisms, which is to say that if the right owner withholds access to that particular subject matter or makes the access to that particular subject matter contingent on paying an exorbitant price, or that he does not manufacture the particular commodity in enough quantities so that people at a large scale have access to it, then effectively what happens is these forms of intellectual property rights under the statutes are subject to certain mechanisms called as compulsory licensing mechanisms, which means if I as a third party believe that you have gone beyond the acceptable limits of the price with which you could have sold a certain product, or that if there are 1 lakh cancer patients in India and you have not manufactured the product to the extent that it meets the requirements of all 1 lakh cancer patients, or that you have chosen not to manufacture the product at all for whatever reason it may be, then it becomes imperative for each form of intellectual property right and each of these IP legislations to provide for a certain mechanism which allows either the controller or a third party or a competitor or the government to basically ask the patentee or the right owner to make that particular product available at the payment of a certain license fee, which is effectively what is known as the compulsory license, which is a license which is mandated or which has become compulsory as a consequence of a certain quasi-judicial decision. Okay. Now, even assuming for a moment that there is no such mechanism that is available under the umbrella of IP legislations, which is to say that there is no internal corrective mechanism which is available under intellectual property legislations, third parties or even the government for that matter can still fall back on the framework and the canvas of competition law, which is the Competition Act, as indeed previously it was the MRTP Act, now it is the Competition Act, to ensure that a patentee or a copyright owner or any IP owner does not transgress the limits which have been imposed on him by those IP legislations, and to ensure that the market in general has as many options as it is supposed to have to cater to the needs of the public, to cater to the needs of the market, so that the market and its free forces, relatively free forces, are not held hostage by one particular entity merely because he or she has a certain form of intellectual property right. Okay. So there are two aspects that I'm trying to address here. One, that when intellectual property rights as a certain creature exists, there is one internal corrective mechanism to prevent its exploitation, to prevent its unreasonable enforcement within IP legislations themselves. So therefore, there is an internal form of correction that is available, internal competitive correction that is available. Then the other is the form of corrective mechanism that is available under the Competition Act, which is outside the scope of the IP legislations. Okay. So this is effectively the broad backdrop in which I'm going to try and address certain issues. So the two specific provisions of the Competition Act which become very, very relevant from the standpoint of addressing IP abuse or intellectual property rights abuse are sections 3 and 4 of the Competition Act. Section 3 specifically speaks of bar on anti-competitive practices, and section 4 broadly speaks of a prohibition against abuse of a dominant position of a certain player. Now, most practitioners of competition law will try and tell you that the primary distinction between sections 3 and 4 of the Competition Act is that Section 3 largely addresses the issue of cartelization, where a group of people come together to hold the market hostage and to artificially rig the market and deprive it of its legitimate options and basket of options. Whereas Section 4 largely speaks of abuse of dominant position by a single entity, which is to say one particular entity holds such a dominant position in the market that it cannot be affected by the rest of the market, and it is in a position to affect the market entirely on its own, which is to say, market forces do not affect its ability to take a decision, but any decision taken by that particular entity has the effect of affecting the rest of the market. That is the sum and substance, the pith and marrow of what constitutes a dominant position. So these are two different forms of anti-competitive practices, broadly speaking, which are addressed by the Competition Act, Section 3 and Section 4. Now, students of law, practitioners, and those interested can read two wonderful decisions on this particular issue, where there is a detailed analysis of the relationship between intellectual property rights and competition law. Specifically in the context of Section 4, abuse of dominance, there's a brilliant judgment written by Justice Thru, which was pronounced in 2015, in the context of the relationship between patent rights and Competition Act. Effectively, in that particular judgment, Justice Thru has explained the fantastic relationship between Section 4 of the Competition Act, which relates to abuse of dominant position, and the Patents Act, which is to say, how do these two legislations work with each other? Do they undermine each other? Are they mutually exclusive or destructive? Or is it possible for both these legislations to work together in a complementary fashion? So this is the issue that Justice Thru tries to address as part of his judgment, which was pronounced in 2015. In Ericsson versus Micromax and Intex, this is a matter which I continue to be a part of, and I've had the benefit of, or let's say the good fortune of being a part of. I had the good fortune of assisting the court apart from other senior counsels, or along with other senior counsels. A fair point of disclosure here is that this particular judgment is the subject of an appeal before the division bench of the Delhi High Court, and therefore, for all practical purposes, the judgment is not final. This is something that I'm duty bound to point out, and therefore, while I believe that the judgment of Justice Thru is correct in law and is good law, what it ultimately translates to and how the division bench of the Delhi High Court takes a position on it is something that I'm not in a position to predict, as no lawyer is ever trained in the art of astrology. So I'm not in a position to actually tell you what could ultimately come out of it. But I am of the view that the judgment of Justice Thru in that particular case was correct, and I'll discuss that judgment shortly before I open it up for questions. Then the second judgment, which is of relevance to this particular discussion, is something that was pronounced this month, earlier this month, on the 20th of May 2020, by, again, Justice Thru, in the context of Section 3(5) of the Competition Act and its relationship with patent rights. And in this particular judgment, Justice Thru has again relied upon some of his findings in the Ericsson judgment, which was delivered in 2015. So in a span of about 5 years, you've had two fascinating judgments which are contributing to the evolution of jurisprudence on the interplay between intellectual property rights and Competition Act. While both these judgments are largely in relation to patents and Competition Act, I'm sure that there are certain principles and there are certain observations which form part of the ratio of these judgments, which can be extrapolated to other forms of intellectual property as well, and not just to intellectual property rights. So these are the two judgments which I would certainly recommend reading. So let me try and break down for you the broad points or the summary of these two judgments, which I think is the sum and substance of Justice Thru's position on this issue. Now, intellectual property owners, at least there is one school of thought among them, which basically takes the position that intellectual property rights are the creature of specific legislations. They are the creatures of specific sui generis legislations. And these legislations are self-contained codes. And therefore, any limitation on intellectual property rights, or any limitation with respect to their abuse, or any mechanism which addresses IP abuse, cannot be traced to a general legislation such as Competition Act, but must be traced within the four corners of these IP legislations. Simply stated, if you're a patentee, your position as a patentee is that if I abuse my patent right, then any limitation, any restriction, any form of suspension of my right, any form of revocation of my right, or any kind of mechanism that leads to a compulsory licensing must necessarily be limited to the four corners of the Patents Act, and there can be no interference with my rights through the prism of the Competition Act is your broad position. The contrary position, the opposite position, is the Pro-Competition Act position, which basically says that the Competition Act is not a general legislation. In fact, it is the specific legislation with respect to competition, the specific legislation with respect to how players act in a market, and is the specific legislation that deals with the aspect of conduct in a free market or in a relatively free market. Therefore, IP rights may be specific only with respect to IP related issues, but with respect to market related issues, it is the Competition Act which is the specific legislation. Secondly, an interpretation has been undertaken based on sections 60, 61, and 62 of the Competition Act to basically arrive at the position that the Competition Act specifically contains an overriding provision, which means that the Act must prevail over any other legislation which is directly in conflict with it or which is at loggerheads with the Competition Act. Therefore, assuming for a moment that there is any kind of conflict between the Patents Act and the Competition Act, proponents of the pro-competition position effectively take the view that the Competition Act must prevail over the IP Act because the Competition Act is the primary legislation which deals with the question of a free market. The second argument which is given in favor of the pro-competition position is that it is possible for the action, the unreasonable action or the anti-competitive action of an IP owner to be limited using IP legislations as well as the Competition Act, which basically means that options under the Patents Act or any other IP legislation continue to be available independent of the options available under the Competition Act. Similarly, options available under the Competition Act are equally available as options available under IP legislations. Therefore, specific remedies under those specific statutes are available, and broader remedies under the Competition Act are also available. Therefore, both sets of remedies are available to anyone who wants to question the unreasonable exercise of IP rights by an IP owner. Now, this is broadly the position that Justice Vibhu Bakru has actually taken as part of both these judgments. There is a lot more nuance that is possible on the basis of the reading of these two judgments. And I would request members of the audience to actually, or the listeners to actually read through both these judgments and come to their own conclusions. I'm merely presenting the broad framework. I'd like to open the floor for questions now, and I'll take as many questions as I can. Anand, I would request you to moderate the questions, please.
Yeah. Thank you, Saiji, for this wonderful insight on the IP and competition law basics. And I think there are few participants who are not able to join in this session. I think few of them are continuously raising requests, but they are not able to join inside. I think there is some technical error in this. But since the entire event is recorded, the entire event's details will be sent to them. And there are few people who are who have asked the question already in the chat. And one more thing for all the participants, those who want to ask the questions, may kindly put your question in the chat so that I will ask to the special speaker.
So, okay, let me just take a look at the
Muthu has asked,
right,
in the trademarks, why some of the trademarks are looking similar? How they give certificate of trademarks to their companies?
So, for the benefit of the audience, where I think Deependra Singh Chauhan has asked me to share the name of the second judgment, I'm sharing the link to the second judgment from Indian Kanun. So this is Monsanto Holdings Private Limited versus Competition Commission of India, dated the 20th of May 2020. Writ petition 1776 of 2016. And this is delivered by Justice Vibhu Bakru, as I mentioned a few minutes ago. So it's writ petition 1776 of 2016 and writ petition 3556 of 2017. Okay, so I've shared the link on the chat. So that's point number one. Second, coming to Mr. Muthu's question, without registration of copy, okay, sorry, in the trademarks, why
Yes.
some of the trademarks are looking similar, how they give certificates of trademarks to their companies. So one of the things about examination of any form of intellectual property right, whether it's, let's say, trademarks or geographical indications or industrial designs or patents for that matter, is that the process of examination is not completely foolproof. It is capable of missing out on a lot of points which are already available in public domain, which is why what happens as part of these mechanisms is that once the trademark office or the patent office or the GI registry undertakes an examination of the application before it, if it finds that there is something already in public domain or as part of existing registrations which comes in the way of the grant of registration to a certain application, it raises a red flag. Assuming that they are not in a position to raise a red flag or it completely misses their notice altogether, then it is left to members of the public or interested parties to participate in these proceedings either by way of a pre-grant or a pre-registration opposition or a post-registration or a post-grant opposition or a revocation proceeding, so that you're in a position to bring to the attention of the granting authority that the right that they have granted over a certain subject matter, they shouldn't have granted in the first place for certain grounds, either that it is already in public domain or it is against public morality or it is against principle of natural justice or whatever it may be. Any number of exceptions or any number of grounds can be raised as grounds of challenge. Therefore, the one thing that we must understand is that the process of examination of application for intellectual property rights, any form of intellectual property right, is ultimately a process undertaken by a human being. Therefore, it is bound to be prone with a lot of human errors, and these errors of judgment are sought to be addressed by providing mechanisms to third parties who can address and rectify those errors by bringing to the attention of the granting authority the mistakes it has made in the grant of those rights. So that's point number one. I think Muthu has raised a second question as well, which is without registration of copyright in the subject matter of artistic work and literary work, whether the person who has created the work can succeed for infringement of copyright under Copyright Act. Yes. In India, it is possible for you to assert your copyrighted work against a third party on grounds of infringement without registering the copyrighted work. Some jurisdictions have the requirement of registration in order for you to initiate an action for infringement. Copyright in India does not require registration for it to be asserted in an action for infringement. United States requires a registration, but in India, if you have a registration, it helps you to prove your right even better because you have satisfied certain evidentiary requirements. But since there is no requirement for registration for grant of a copyright or for, let's say, not the process of grant, but for the coming into force of the copyright as a right in a certain work, you don't need to register it at all. That is the primary difference between copyright and patent right. Patent right necessarily comes as a consequence of examination. Copyright comes into existence the moment the work comes into existence. That is the primary difference. So that's point number two.
Yeah. Next.
Ankit Rai, I think, has asked a question. I'll just share the other judgment also, which I think Rinku Savla has asked for.
The next one is from Mr. Ritik Verma.
Right.
How does law affect pre-market? Can you explain?
I'll just explain that.
Yeah.
So here's the link to the other judgment. I'm sorry, it was not 2015, it's March 2016. I'm just sharing that here. So I've just shared the link to the other judgment, which is the Ericsson versus Competition Commission of India, 30th of March 2016, delivered in writ petition 464 of 2014 and 1006 of 2014 by Justice Vibhu Bakru. I've just shared the link as well. Ritvik Verma's question is, how does competition law affect free market? Can you explain? Now, strictly speaking, the concept of an absolutely free market does not exist in any jurisdiction, to the best of my understanding. People are welcome to correct me here, because there is always some form of regulation of the market in public interest, because the government has to protect certain interests, and therefore there is no concept of an absolute free market except in paper, except in theory, or except on paper and except in theory. So how does competition law affect free market? is that the market regulator, namely the Competition Commission, is expected to prevent participants in the market, players in the market, from violating the rules of the relatively free market, or from subverting the rules to their advantage, or by arrogating to themselves all form of economic power, so that they are no more in a position to be governed by the rules of the market. So competition law acts fundamentally like a safety valve to ensure that private players do not keep changing the rules of the game to benefit themselves at the expense of other players in the market, as well as at the expense of the consumers in the market. Because the moment you affect the ability of other players to either exist or operate in the market, you deprive the customer of his choice of options, of his basket of options, so that he has more than one person to choose from. That is the fundamental role of competition law. Competition law is not meant to protect any particular player. It is meant to protect the integrity of the market, meaning thereby every player in the market has the right to expect fair treatment. And the consequence of such fair treatment is that the consumer benefits, because there are a significant number of options in the hands of the consumer, as opposed to being exclusively dependent on one or two entities. So if you go to America, for instance, whatever little I have noticed of that place, if you happen to be a mobile phone subscriber, you barely have 2 or 3 options to choose from in terms of networks, or even in terms of brands, in terms of handsets. And to my mind, that is one of the textbook definitions of a jurisdiction where antitrust regulation is necessary, where the existence of a competition commission or a competition regulator is extremely necessary, because there are so few players in the market and they hold their market shares to such an extent that it becomes difficult for a new entrant to the market to make his presence felt. There is a huge entry barrier. So if there are only 2 people, you effectively are at the mercy of those 2 people. It's almost as if you're, let's say, a citizen of the state of Tamil Nadu, where you have only the option of voting for DMK or ADMK, but other than that, you don't have any other credible option to vote for. Okay, so in that sense, you can think of the Competition Commission as a market regulator who is meant to facilitate greater access to choices for the customer. So
The
that's
next one.
yes.
Yeah.
Prasoon Vashisht, I think, has asked a question.
Yeah, one more. Yeah. What
What
are the effective ways to curb the prevailing trend of the local market, pan India, infringing the trademarks of already established brands by using those logos in their products? Just like if you would have seen in Tamil Nadu Talapakatti biryani,
right?
there are so many Talapakatti biryanis.
Right.
Original Talapakatti biryani, Rautar Talapakatti biryani, like that. So he's asking, even in Delhi, Saravana Bhavan, there is Saravanan Bhavan, there is Hotel Sri Saravana Bhavan.
Okay, I didn't know this.
Yeah.
So, Prasoon, to answer your question, there is no one single blanket solution for this. Since it is a private right, every right owner must undertake the responsibility and must do whatever is needed to protect that right by initiating enforcement mechanisms which are available under the Trademarks Act. So you have options under criminal law, or you have, let's say, the option of pursuing a criminal remedy against an infringer. You have the option of pursuing a civil remedy against an infringer. So there is no possibility of expecting a third party to fight for you. It is your right. You are the author. You are the owner. You are the proprietor. Therefore, you are expected to spend resources to protect your right. So think of it as your land, or think of it as your home. You don't expect everybody else to protect your land or your home. You try and protect it from any kind of trespass by creating a boundary around it, by taking legal action against anyone who steps into your territory without your consent. That is the same logic that applies to intellectual property as well. So that's the answer to your question.
Yeah.
Then
one more question which we have left is asked by Mr. Ankit Rai. Right. What are your views whether the IP legislation competition law is complementary in nature, or overriding clause in Competition Act makes it superior?
No. So this is my reading of it, and I have written to some extent about this in my paper on the interplay, the jurisdictional interplay between intellectual property rights and competition law. One, as long as there is no conflict between Competition Act and IP legislations both can operate and both are equally applicable to a certain transaction or to a certain issue. However, the moment there is any kind of conflict between these two legislations, Section 62 makes it abundantly clear that the overriding effect of the Competition Act will ensure that it prevails over, I think it's Section 60 or 62, my memory could fail me here. Effectively, it ensures that the Competition Act supersedes, overrides, and prevails over IP legislations. So if there is no conflict, both legislations apply simultaneously. But if there is a perceived conflict or if there is a clear case of conflict, then the Competition Act applies. That is the mandate of the Competition Act, because it is meant to be a super market regulator in that particular sense. And most importantly, the one thing that people must realize is that the controller of patents or the registrar of copyrights are not market regulators. They are the regulators of certain forms of rights, which is to say they either grant it or they limit it or they register it or they grant compulsory licenses with respect to those forms of rights. But the purview of the market, which is such a broad canvas, is something that is not the purview of the controller of patents or the registrar of copyrights. Their scope of purview and their scope of jurisdiction is extremely limited. It is right specific. A market-oriented approach is the sole preserve and the primary preserve of the Competition Commission, which is why it must necessarily prevail over IP legislations.
Thank you, Mr. Sai. Next one is from Mr. Vatsalyan Sridharan. Please share your thoughts on the effect of IP and competition law after COVID-19.
So, I don't know if it is possible to address every issue through a COVID-19 prism, but what is possible is that if any player in the market who holds a dominant position chooses to exploit the customer in this extraordinary circumstance, then it is possible for trigger, let's say, mechanisms both under IP legislations as well as competition law to be invoked against that particular party. So let me make it even more blunt. Assume for a moment that there's a pharmaceutical company that is in a position to manufacture any drug which can be used either to treat or for the vaccination of COVID. And realizing that it alone has the ability to actually manufacture that particular product, it chooses to charge an exorbitant price and sells the product at an exorbitant price, making it unreachable or inaccessible for certain sections of the public. Then under the Competition Act under Chapter 16, under the Patents Act under Chapter 16, you can invoke the compulsory licensing mechanism if that particular product is the subject of a patent. But assume for a moment that the product is not the subject of a patent, then you must still have some kind of a mechanism to go after an unfair business practice of a dominant player in the business, whether or not he or she owns a patent right. That is why Competition Act becomes such an important tool, because even if you don't have a patent, but you still exert a certain form of non-patented monopoly over a certain pharmaceutical drug, then obviously a non-patented drug cannot be the subject matter of compulsory license under the Patents Act, because Patents Act is exclusively concerned with patented products. If the drug is non-patented and you still own some form of monopoly, which you're exercising to the detriment of the market, then your remedy must be under the Competition Act and not under the Patents Act. Which is why, depending on the kind of entity you're going after, depending on the kind of right that particular product is covered by or protected by, you can choose your options between the Patents Act and the Competition Act, or in some instances, you can use both these legislations.
Now, the next one is from Mr. Vijay Krishnan RP. What is your opinion on transfer of technology and IP laws? Does IP laws provide for efficient TOT, or is it an impediment for the same?
Before I lose my laptop, let me just charge it for a moment, please. Just a second. So sorry. So this is Vijay Krishnan's question on whether IP laws provide for efficient transfer of technology, or is it an impediment for the same? IP laws don't necessarily create an impediment to the transfer of technology. According to me, they provide a better framework to understand how technology may be transferred, or whether a transfer is necessary, whether something is available in public domain. So let me put it in this manner. Somebody chooses to come to you and says, I own this particular form of information, and unless and until you take a license from me under a technology transfer agreement or some form of transaction between us, you will be in violation of my rights. Wouldn't you want to know whether that particular information can actually be protected or can be owned by one single person? Wouldn't you want to know whether there is something in the law that says that something which is in the realm of public domain cannot be picked up by an individual and then claim ownership of it? Therefore, IP laws don't necessarily pose an impediment to efficient transfer of technology. They facilitate it better. In fact, you have to understand that in certain situations, the person who owns the technology may be a small entity, and the person who wants to own that particular technology may be a larger entity, and therefore there is a very clear disparity in negotiating power between the two parties. In such a situation, intellectual property rights are effectively to be seen as laws which protect the rights of the smaller party, or let's say the weaker party at the negotiating table. That's one of the reasons why the Copyright Act was amended to strengthen the position of individual authors and composers and lyricists, so that they are not deprived of their rewards when they negotiate their licenses with music recording companies or directors or producers. Similarly, there are any number of instances, even when it comes to patents, where a small entity which does not have a large distribution network or a large market share decides to make its presence felt in the market through its innovation and comes out with a fantastic product. Then the bigger entity chooses to either acquire or somehow deprive that particular small entity of its right over that piece of innovation, because the bigger entity realizes that the small innovation, or rather this innovation by the small company, represents a fantastic market opportunity. In such a situation, it is intellectual property right which forces the bigger entity to respect the rights of the small entity, because there is a framework of ownership, there is a framework for a license, there is a framework that requires all third parties to respect the right of that particular small entity. So whenever we think of intellectual property rights, in our minds, we constantly have the stereotype that it's the big entity which owns the intellectual property right and comes after smaller entities. In any number of instances in real life, the opposite is true. The smaller entity owns the intellectual property, the bigger entity has market power, and the bigger entity is forced to respect the right of the smaller entity because of the existence of intellectual property rights. Okay, so these are certain instances that practice will teach you on and on. Popular culture constantly gives the impression that only Western or foreign multinational companies are the ones which own intellectual property rights. That's not the case.
Thank you, Saiji. Now moving on to the next question. It has been asked by Ms. Tanya Tare. Wasn't the fundamental rule of competition violated when Jio provided free SIM cards to all back when it was launched?
So, Tanay, I think it's a very good question, because it is possible, or it was possible at that time, for someone to go after, I think, Reliance for using its strength in one particular market to push its way or elbow its way into another market, and that too at the expense of every other player in the market, by introducing SIM cards at throwaway prices, and perhaps that could come within the definition of predatory pricing. So that is something that could have been considered against, or let's say explored against, Reliance at that time. And here's something that's very, very important. A remedy under the Competition Act can be initiated by any person. You need not be a person from that particular fraternity. You need not be a competitor in that particular field. You need not be a participant in that particular market, in that particular relevant market, for you to say that this is fundamentally anti-competitive or this is fundamentally an abuse of dominant position. So the beauty of the Competition Act is that any person can approach the Competition Commission with information to basically say, according to me, this particular act of this dominant player in this market constitutes abuse of its dominant position. because by selling or offering its product at such dirt cheap prices or predatory prices, it has endangered the commercial viability of every other competitor or every other entity in the market. And while in the short run, I may benefit as a customer, in the long run, I will be rendered entirely dependent on this single entity, because all other entities would have been wiped out from the market thanks to the action of this particular entity. Okay. So Competition Act, according to me, is an elevated form of Consumer Protection Act in a certain sense, which gives the average consumer sufficient remedies, I would say at least some remedy, for him or her to approach the Competition Commission against the brazen act of a market behemoth. If somebody is a giant, it's possible to take down that giant exercising the remedies under the Competition Act. I believe that the Competition Act has not been given enough attention by a lot of people, because they think of the Consumer Protection Act immediately, but they rarely consider the Competition Act. Perhaps it's time for us to change our approach to the Competition Act.
Thank you, Mr. Sai. Actually, it was Mr. Tanay. It was my mistake. It was Tanay Tare. Yeah.
Right.
And then moving on to the next question. What should be the leading criteria when trying to find a balance between the competition law and IP law? The question is asked by Ms. Parinita Goswami.
Just a second. What should be the leading criteria when trying to find the balance between competition and IP? Okay. So I don't know if I have a clear-cut and a comprehensive answer to this question, because you see, it depends on the form of intellectual property to a significant extent and the considerations. But the overall balance that I think you're trying to strike is broadly captured, I think, in Section 3(5) of the Competition Act itself and Section 4 of the Competition Act. So under Section 3(5), an IP owner can take all reasonable measures to enforce and to exploit his intellectual property rights, even as part of its licensing arrangements or as part of its enforcement actions. However, if that threshold or if that bright line of reasonableness is crossed, then it effectively enters the realm of an act which is anti-competitive in nature. Now, the question can then be, who decides what is reasonable and who decides what is unreasonable? It is for the Competition Commission to decide what amounts to a reasonable practice or a reasonable measure in the enforcement of intellectual property rights by any IP owner. Okay. In fact, that is where the judgment of Justice Vibhu Bhakra in the Monsanto case, which was delivered this month on the 20th of May, becomes extremely relevant, because Justice Bhakra undertakes a detailed analysis of the metes and bounds of Section 3(5) of the Competition Act in understanding what kind of terms can Monsanto impose as part of its license when it licenses its technology over BT cotton to farmers. Okay. And what kind of terms effectively are unreasonable, what conduct becomes unreasonable. That is the broad subject of this particular judgment, which is why I think you should read this particular judgment, because it is directly on point and could help you understand the answer to your question even better.
Thank you, Mr. Sai. That was well answered. The next one is from Mr. Krishnan P. With respect to Mr. Ilayaraja claiming royalty for his tunes and restricting Mr. SPB not to sing songs composed by him in any public forum. If it is so, he has to be compensated. My question is, once payment has been made by the producer, whether the composer can keep claiming royalty. Now, recently another controversy happening in dance field about songs and talams composed by yesteryear gurus and their legal heirs claiming rights. Is there any solution for these kinds of issues? In fact, Mr. Ilayaraja's brother Gangayamaran, once when he was interviewed, he actually said, what will happen if yesteryear Mahans like Sri Tyagaraja's Kirtanams were coming under this IP and copyright, and if their ancestors, their successors start claiming about their royalty. Right. So even his brother was not in the view of what Mr. Ilayaraja was asking, and in fact, people are getting confused with what is happening in US and what is happening in India. So I would like you to clarify on these issues.
On the question of Tyagaraja's Kirtanas and copyright over his work, I had the opportunity to write on this particular issue, I think between 2012 and 2013. There's an article that I've written which is publicly available. Now, the first point is, there is a specific term or a life for a form of IP right. Now, when it comes to the Copyright Act, the question is, when did the copyright in Tyagaraja's Kirtis effectively end? Okay. Therefore, the question would be, what was the applicable period of duration for copyright over his works? Now, given that at least a couple of centuries have passed since the Samadhi of the great saint, okay, there is no form of, or there is no term under the Copyright Act under which his legal heirs can assert rights over his works under the umbrella of the Copyright Act. Okay, because it is lifetime of the author with either 60 plus 60 or 70 years. Now, even if you take the period of demise of Tyagaraja, I think he passed away sometime in the late 18th century or the mid 18th century, to the best of my understanding. If that is the case, you add 60 or 70 years to that, even then there is no way that anybody in the 21st century can hope to assert any form of copyright with respect to Tyagaraja's Kirtis. However, if somebody wants to use his work without attributing him or without saying that this is Tyagaraja's work, then that is a form of violation of what is known as moral rights under the Copyright Act. So even though there is no duty to pay a license fee to the heirs of Tyagaraja's successors, they certainly have the right to say, or any person has the right to say, according to me, that the work which belongs to such a noted saint must be attributed and people must highlight the fact that they have sourced it from this source. So apart from the question of license fee, the central issue which arises from Copyright Act is the issue of attribution. Is the question of acknowledgement and crediting. So if somebody fails to perform that particular legal duty, then you still have a cause of action against that person for failing to respect the moral rights of the author or the owner. Okay, that's one. Second, I'm not a trained student of history, so I don't know whether Tyagaraja himself owned the rights over his Kirtis, because what if he was performing it or he had composed it on commission or for somebody else? Okay, that is a history that I'm not aware of. Because the moment that also comes into existence, while Tyagaraja's legal heirs can continue to assert moral rights, perhaps copyright never vested in him in the first place, because he may have actually done it for somebody else, because then it becomes work for hire or work, let's say contract of service or contract for service. Therefore, the principles under section 17 of the Copyright Act will immediately kick in. That's point number one. Now, coming to the issue of the controversy between the music maestro Sri Ilayaraja and SPB, the one thing that you have to realize is the composer is paid by the producer only for using that music as part of the film, as part of a cinematograph film. And the moment that work is used independent of that particular medium, and it is performed on radio or it is performed in a live show for which somebody charges money and somebody is paid for, and somebody sells tickets and somebody pays for that particular ticket, okay, then clearly there is a commercial element involved. And most importantly, the transaction that took place for the movie is no more applicable to this. So that is precisely the reason why you have the Copyright Amendment Act, which effectively protects the rights of music composers, the rights of lyricists, and all these artists when their works are performed outside the four corners of a movie. So if the song is played as part of a movie which is shown on television, where the movie is again being aired or broadcasted, then there is no problem at all, because it's the entire movie that is being shown. But if the song is removed from that movie, or it is played separately, or it is performed separately, then clearly nobody can say that you have already been paid once, therefore you have no right to assert these rights against me at all. That's not how it works. Second, I think this is a slightly cultural issue. There is a decent chance that intellectual property rights, as we understand it today, is relatively new, and therefore there is a lack of awareness even among members of the performing fraternity or the artist fraternity, which is why these kind of questions arise. However, any average student of intellectual property rights will tell you that while Ilayaraja may have offended certain sentiments merely because everybody sees Ilayaraja and SPB as friends, what he was asking for was fairly arguable within the law, and he was not asking for something that was either unreasonable or illegal or unlawful. Therefore, I think we must separate our personal emotions from the strictly legal question raised by Ilayaraja with respect to remuneration or with respect to the basic question of consent. Can you perform something without my consent?
Thank you, Sai. Thank you, Mr. Sai. One more thing which I would like to add here is people get always emotional when these kind of celebrities start asking money. They think, are these celebrities not rich enough, and why are they asking for more money? In fact, one more thing is whatever may be the reasons, all those people who are inside this film industry are themselves talking bad mouth about Maestro, Mr. Ilayaraja.
Right.
So whatever Mr. Ilayaraja is asking is 100% correct as per the laws. People are always go emotional and do not consider the legal aspects of it.
Right.
The second one is Swamy has been abused adequately of late by so many celebrities,
Right.
and I think he would have performed only out of sheer bhakti and love for the God, and not for any personal or monetary benefits.
Right.
Just putting one more small point here: is it right to nationalize the works of great poets or artists after their demise? It also deprives their legal heirs from getting the exact monetary benefits which they would have got if not the works would have been legalized, nationalized, in fact.
Honestly, unless and until the family or the legal heirs of those artists themselves commit or dedicate those works to the public, I don't think it is right or the government has any powers to actually dedicate it, because if that happens, nobody will have any incentive to become a legend. Because the moment you become a legend, then all your work and your life's, let's say, savings are effectively, or the life's creation are effectively committed to the public, and your heirs may be deprived of whatever is due to them. So legally, I don't think it's permissible, and morally also, I don't think it's right. It's one thing to celebrate a person, it's another thing to appropriate what belongs to them or their creation in the name of celebrating that person. I think we must make a distinction between the two.
In fact, just adding one more point, the works of Subramania Bharati was first nationalized. The works of Mr. Bharatiyar was first nationalized much before the works of Rabindranath Tagore or Jawaharlal Nehru was nationalized. In fact, Bharatiyar spent his entire life in poverty, and I think the much deserved amount which his family or legal heirs would have got, if not that work would have been nationalized, was entirely deprived by, for their family members.
In fact, here there is a small trivia, interesting historic trivia. Bharatiyar is a distant Maplai of my family, or was a distant Maplai of my family. Okay. Oh. So, Enga Veetu Ponnu, which is to say, our let's say the girl whom we had given, effectively suffered at the let's say at the house of her husband, because it was a constantly poor house which struggled to make ends meet. Okay. And apart from that, Bharatiyar, given his genius and given the kind of person that he was, obviously was more suited to the life of a sannyasi than the life of a householder, because he was in love with his country, and he was in love with language Tamil. Okay, so we have different kinds of stories to say in our own family, because we have seen him as a Maplai who actually was more interested in feeding sparrows and crows than the members of his family.
No, in fact, no one else would have loved his wife like Bharatiyar had. In fact, your Veetu Ponnu is very lucky that she got married to Mr. Bharatiyar. So how many verses he has composed just keeping in mind his wife.
That's true. Her only answer would be that if poems could effectively feed the hungry stomach, there's a lot that the world can do.
Yes. In fact, one more small thing which I would like to add here. Once Bharatiyar and Bharati Dasan, another famous poet, where he came to Mr. Bharati, actually he came to Bharatiyar's house, and once when his wife Chalama was not there, and Bharatiyar was actually just trying to, what do you call, in those days that it was Udukuda, they used to just...
he used to smoke, that people know,
Yeah, and he was, at that time he was talking to Bharati Dasan that what I would do if my wife is not here. Only, my entire life's works are being taken care by my wife only.
Right.
So no, I think no one else would have given this much credit to his wife.
That's true.
So the next
How many
question is,
questions? Yeah.
yeah, we'll just take another 3 questions shortly, and then we will wrap it up.
Right.
Another question from Mr. Muthu is it possible to get both the remedies, civil and criminal?
Not for all forms of intellectual property rights, but only some forms of IP have civil and criminal remedies. Patents don't have civil and criminal remedies, but let's say trademarks, copyrights, they have civil and criminal remedies.
Yeah, another question from Mr. Tanay Tare. Should religious symbols have a copyright or trademark with respect to Worldwide Church versus Philadelphia Church of God?
So religious symbols, so long as they do not offend and so long as they do not appropriate what belongs to the public in general or what belongs to a community in general, can be the subject of, let's say, trademarks or copyrights. Assume for a moment that a spiritual or a religious organization comes up with its own set of symbols and which have a clear religious connotation. You can't deny them of any kind of private right. However, if there are any parts of that particular symbol which are part of the common domain. So for instance, assume for a moment that there is a large logo and out of that logo, there is an ohm that is part of that particular logo. Then your exclusive rights do not extend to that specific part which belongs to the public. It only extends to the broad representation. You can't stop somebody else from using ohm as part of their logos or as part of their institutions. So the law on this issue is very clear. Religious symbols can be the subject matter of rights, but religious symbols which belong to the public and which are in the realm of public domain cannot be appropriated by anyone in the name of private intellectual property rights. They can use it as part of their broadly crafted logos, but they can't assert any kind of exclusive rights over something that belongs to the public. That's not possible.
Thank you, Mr. Sai. Another question which has been added here is by Mr. Ramji Muralidharan. Can religious customs or procedures be copyrighted or become IP?
Sorry, come again? What's the question?
No, can religious customs or procedures be copyrighted or become IP?
So religious customs or procedures cannot be copyrighted according to me because frankly, if they have been in existence for more than 100 years or 200 years, there is no question of a copyright that exists in it. However, if somebody tries to appropriate it, as I said, or if your idea is to prevent someone who doesn't belong to the community from using it, then your remedy lies in a slightly different field altogether, which is to say that by seeking to appropriate the customs and let's say procedures of one community by another community, you are perhaps offending the sentiments of the community. You are perhaps, I would say, giving rise to a cause of action under blasphemy laws of the country under section 295A or 153A. That's what I would go with, as opposed to looking for intellectual property rights. There is no protection for any indigenous form of custom or procedure so far under Indian law. While there are certain international discussions that are going on across the world to protect traditional knowledge systems, if we want to treat our religious knowledge as also knowledge in the sense that it is meant to inform you or educate you, then perhaps we can start looking at statutory mechanisms to protect them. I don't think India has looked at it from that standpoint so far, because obviously there are quite a few sensitive and delicate issues involved in this, because it could even take you to the sensitive and controversial issue of conversions, whether let's say the architecture of a temple can be appropriated by a place of worship of a different community, although it's not a Hindu institution. These are questions that it can lead to ultimately. So I think the answer to this lies in addressing it from a slightly different standpoint. Intellectual property cannot be a sufficient remedy against these kind of measures. In fact, it's a very poor remedy as far as these larger social issues are concerned. I think Ms. Lopatagaki has a very important question. I think it's important to answer the question. Let me just address it. The question is, how much right would an artist have over the creation such as painting or sculpture? Would anyone who buys the artwork be able to use it commercially or put it in painting shows? What can the artist do to ensure this doesn't happen? So assume for a moment that you create something and there are multiple pieces of it that you sell to someone. Okay. You're not giving them right over the underlying work. You're giving them right over that particular unit or that particular piece. So instead of thinking of it as a painting, just think of it as a book. Just because somebody buys a book, can they reproduce the book? Can they claim rights over the contents of the book? No. What can they do? They can only use the contents of the book in a very limited fashion, which is what is known under the Copyright Act as either fair dealing or fair use, wherein they can use the contents to the extent that they wish to review the book, or they wish to criticize the book, or they wish to extract certain limited portions of it as part of a larger work. Okay, so there is an entire bunch of case law on these kinds of fair use and fair dealing, let's say, provisions itself. So always strike a distinction between the unit or that particular piece of the article that is sold and the content that it captures. Okay, so a painting as a frame is different from the painting itself as the subject of protection. Okay, so there is a painting which can be reproduced across 100 pieces and sold as 100 pieces. Does it mean that you have given up the right over that painting to all the 100 different purchases of that particular painting? No. What have you given access to them, or what is the permission that you have given to them? You have given them the permission to only use that particular unit, but not the painting itself independent of that particular unit. Okay, so think of it as a piece, think of it as an article as opposed to the painting itself. So when you look at Copyright Act, when the word work is used, it means the subject of copyright protection. And when the word article is used, it is the medium in which that particular work is captured. Okay, so your story or the contents of your story are your creation, are the subject of your Copyright Act, let's say of your copyright, whereas the book in which that particular story is captured is effectively the medium in which it is fixed, or it is fixated, so to speak. So when you sell a book, you don't sell your copyright in the contents of the book. You are merely selling that particular book and nothing else. I hope I've addressed Ms. Lopa Shigaki's question.
Yeah. Next question, I think we skipped one question. It is asked by Mr. Srinath Muralidharan. Yeah. Understand that what Jio did was a predatory pricing since they had deep pockets, and is it against the competition law? However, this made the competitors to reduce the price drastically, which has benefited a lot of consumers. Even after reducing the prices by more than 80%, 80% telecom companies like Airtel are performing really well. If we are to go with the stock market, now doesn't this fall in the same bracket as overcharging? Example you stated as pharma companies. So how does this work?
One thing you have to understand is, assume for a moment that someone decides to charge 5,000 rupees for a small piece of rag. Okay, that is his valuation of what he wants to sell. That is not the subject of either the Consumer Protection Act or the Competition Act. You can only question the price at which a dominant entity sells its products or its business practices, but you can't question the price at which every entity sells its products, because that is ultimately the concept of market forces at play. I may believe that what I wish to sell has a certain value in the market, and I may believe that there are people who are in a position to purchase it. The only limitations on my ability to sell it at a price that I want to command in the market is if I'm a dominant player, or if the product, or let's say if the subject of that particular sale is the subject of intellectual property rights, then compulsory licensing comes into the picture. So the point I'm trying to make is to address your underlying issue. Please don't be under the impression that every instance of overcharging by every private entity is the subject matter of competition law. That is not the purpose of competition law. Only if you happen to be an entity which is in a dominant position, then your business practices can be called into question. Otherwise, every entity's price at which it sells its products can be the subject of Competition Act or competition litigation, which is not the purpose of the Competition Act. Let's look at it this way. If there is a particular piece of real estate and somebody decides to sell it at 20 times the price of market value, can you immediately go after him either under the Competition Act or the Consumer Protection Act? Not at all, because he believes that somebody is willing to buy it, or that is the market value of that particular product. Okay, that is where the concept of a market force kicks in, and that is where the concept of demand and supply kicks in. The only reason why a dominant player's actions become the subject of competition, let's say, purview, is in a room. Assume for a moment you treat the market as a room, and there are 20 or 30 different people in the room, and your height and breadth are so much that any movement by you is bound to affect everybody else's ability to move in that room, and any action that they take will not affect you. That means you are in such a position that you're almost independent of market forces. Only that entity which occupies a position which is independent of market forces and which can affect market forces almost single-handedly, only that entity's practices can be called into question, not every entity's practices.
Yeah, I think, thank you, Advocate. I think Srinath Muralidharan would have got the answer for what he had asked. Now moving to the next question, asked by Mr. Shubham Kumar. Big music houses repeatedly copy contents of small artists and musicians and do not even give them royalty. For example, Ritviz versus T-Series, which created a big controversy on social media, and T-Series was even trolled. Your views?
Well, life is unfair, and legal remedies primarily exist to try and put big entities in their place if they ride roughshod over the rights of small individuals or smaller entities. But law always tries to keep pace with this. I'm not saying that it's perfect. I'm not saying that it's adequate. But every legal mechanism will always find a loophole. There will always be a backdoor, because that is the nature of business and that is the nature of how market forces operate. Law, according to them, is to be respected in breach and is to be respected to the minimum possible extent and not in its entirety. So what can you perhaps do? I mean, what you can perhaps do is that why don't small artists come together, form an association of their own, create a legal corpus on using which they can fight these big entities if they're not in a position to handle them on their own. Are they united enough to take that decision? Because you see, in certain jurisdictions like Australia, there is the concept of collective bargaining of smaller entities against a huge entity against which none of them can individually bargain. If 10 different people cannot individually bargain with one huge entity, then the law recognizes their ability to collectively bargain so that they can benefit and they're in a position to have at least some of their terms accepted by the bigger entity. And that would not amount to cartelization in some of those jurisdictions. It is my case that collective bargaining is recognized even in India as an exception to cartelization under Section 3 of the Competition Act. So the response there is not just the law. The response there would be to try and look for concerted action where people who are similarly placed when it comes to negotiating power are at the same side of the table when they try and protect their interests against one big entity. That's the way to go about it, according to me.
Yeah. I think in India, once if these small parties form an association, immediately politics will start kicking in.
That is also
They start fighting among themselves.
Correct. One can never be sure that all small entities or all small artists necessarily have the same position. If one of them is offered a better position by the bigger entity, then he will necessarily compromise on the interests of his other stakeholders.
We are really running out of time. We have the last question for the day. Please share some lights on key findings of Patel Field Marshal case related to rectification proceedings of trademarks. I think you can just finish it off in another 3 minutes.
Yeah. So here is the simple issue with respect to Patel Field Marshal. Since I had the benefit of appearing in this case, I can share my views on it. So there are two circumstances which you try and address as part of Section 124 of the Trademarks Act. Okay, one, assume for a moment that there are two trademark owners. Okay, or let's say there are two entities, entity A and entity B. Entity A owns a trademark which is registered, and entity B is sued by A. So A sues B, very simple. Okay. Now B has two options. B can say he does not infringe, or B can say that whether or not I infringe, your trademark registration is fundamentally invalid. You should have never got the trademark registration in the first place. Can be B's position against A. Now, if B approaches the trademark registry to seek rectification or invalidation of the trademark registration before a suit for infringement is filed by A, then effectively the consequence of one aspect of section 124 is that the suit for infringement has to be stayed because there is a prior filed rectification proceeding which has been filed before the suit has been filed. In effect, what it means is, when the question of invalidity of a trademark registration is raised before a suit for infringement of the trademark registration is filed, then the suit has to be stayed. Okay, that's point number one. What is the second situation? That B, which is the defendant in the suit, raises a challenge to the trademark registration after the suit is filed. Okay, so in the first situation, the suit is filed after the validity is challenged, and in the second situation, the suit is filed and then the trademark registration's validity is challenged by the defendant. When that happens, what section 124(1)(b) effectively translates to, and that is what the Supreme Court ultimately laid down, is that the defendant has to convince the suit court or the court in which the suit has been filed that he has a valid prima facie case to challenge the registration of the trademark, and therefore he must be allowed to challenge the registration of the trademark despite the fact that a suit has already been filed. Why is this happening? Because if the suit carries on and you go and independently file a rectification proceeding for the to challenge the registration of the trademark, then the suit can come out with a different outcome, and the rectification proceeding or the invalidation proceeding can come out with a different outcome. So the suit court may grant an injunction against you, and the IPAB may end up revoking the trademark registration altogether or invalidating the trademark registration. Okay, so to prevent the possibility of conflicting outcomes, section 124(b) comes out with a certain sequence of events where it says you cannot challenge the registration of a trademark after a suit is filed without seeking the permission of the court, or without informing the court that, or without satisfying the court that prima facie your case it has some merit. You may not be 100% right. That is a decision to be taken by the forum which ultimately looks at the question of invalidation. But are you at least presenting a case that is worth looking at, or are you raising a frivolous defense only to prevent the progress of the suit in the trial court? Okay, so Patel Field Marshal effectively says that once a suit for trademark infringement is filed based on registered trademark, the defendant must prove that there is a prima facie tenable case in order for him to approach the IPAB for invalidation of the trademark. And once the suit court is convinced, it will grant the defendant a 3-month period for him to file that invalidation proceeding. Then the defendant will come back and inform the suit court that I have filed a revocation proceeding or a rectification proceeding, therefore now stay the suit. Okay, so which is why section 124 speaks of stay of infringement proceedings or suit proceedings, and this is primarily and solely limited to registered trademarks and only in the context of trademark infringement, not for passing of suits under section 27. There's a decent chance that those who are not from this particular fraternity may not understand this, but I'm sure that those who practice this area understand the distinction between an action for passing off and an action for trademark infringement.
Yes, I think there are a lot of technical points in this. Those students who are participating in the seminar may find it difficult to understand, but I'm sure once they come into practice, once they come for the practice, I think what are the words you have told today will come to their rescue.
Thank you.
With these questions and with this question answer session, I think this is the wrap for this today's webinar. I thank our special speaker, Advocate Sai Deepak ji, for presenting a wonderful webinar. It was really knowledge. It was a great session, and really there are a lot of questions which you have answered, and it was answered in a very easy and lucid manner for all the people to understand. And I think the entire success of today's program lies in the way you have handled this session, whole session independently. And I think what are all the inputs you have given, all these advocates and people who have attended the session will have a great insight on this. I thank you, Sai ji, for this, and I also thank all these participants who have asked these questions also. And we look forward to one more webinar from you, Sai ji, in near future.
So, thank you for the opportunity and questions. So thanks a lot. I hope I was able to at least address some of your questions to a satisfactory level. I'm happy to take questions offline as well. Thanks a lot.